Again, my name is Patrick Davenport. I'm Cumberland graduate. I practiced in Birmingham at a tax firm for a number of years before I moved back home to Dothan. We had a 2-year-old daughter, and my 2-year-old daughter said, when asked if she knew who her grandparents was, she said, yes, the folks that come see us sometimes on the weekend. And I thought something's fundamentally wrong with that, so we moved back home, and we've been here about, I think David's just walking around to stay awake. We've been back here about 15 years. I practiced in my years here primarily in the area of business planning, estate planning, and probate, and worked in all the courts around here, both in circuit and district and probate courts. So thank you for letting me come and talk to you a little bit this morning. I had an interesting, I've only been in office for 2 years, so I had an interesting situation just in the last few days. We were at I had to go and eat barbecue at the Porktoberque and see how many hot wings you could eat in so many minutes, and I got wrangled into that. So when I got through, this lady, I was trying to get something for my kids to eat, and this lady came up to me and she said, Judge, I had an interesting thing happen to me just the other day. And I said, what's that? She said, well, I was at church, and this lady came up to me and she said, an elderly lady, would you pray for me? And she said, sure, what's going on? She said, well, I think my husband must be having an affair. He's seeing a lawyer. And she said, oh, goodness, I hate that. And she said, how do you know that? She said, well, I saw the checks in his checkbook. He had gone to see this lawyer, Patrick Davenport, and he had written him a check for $18.50 and $32. And the lady said, I don't think that's right. He's the probate judge now. Have you just gotten your tags redone? She said, oh, yeah, we did. She said, well, I'm just not sure that a lawyer's going to see you. I'm sure y'all are not charging $18 and $18.50 and $32. So that's the interesting story of my life of recent days. What I wanted to talk to you about this morning, hopefully this won't bore you. And I love this stuff, but it's not as flamboyant as most of what y'all are used to with interesting personal injury cases and wrongful death cases. But it is critical to what you do. So these guys have asked me if I would address some of these issues, and I was glad to do that. I have great respect for these guys, and you know I must, because Houston County Probate Court is closed on Friday. So for them to get me up and I have to shave and put on a suit on Friday morning, I really thank a lot of you guys, so I'm honored to do it. Okay, what I first want to do is walk you through the process of what an administration kind of looks like, and I'm going to start by going through kind of the law and application. And as you guys know, probate courts around the state do things very differently. You might see one procedure in probate court in one county and completely different in another, and I'm probably one of the instigators of some of that. So I want to walk you through that. The process first begins with a petition. And there's a number of things we're trying to find out when you file that petition. And we're asking that you file something succinctly and accurate that is sufficient to allege a number of things. But the two first things we're trying to get after is to determine, like in all cases, first to determine jurisdiction, and secondly, as to the petitioner's qualifications to serve. So the first thing we're going to do, and all of this is codified in 43:2 throughout that chapter. You begin with somewhere around 22 where it starts to name the requirements of who that petitioner is. And I've got all these documents that I can provide for you guys. Let me do mention what I did give you is what we call it as Administrator's Handbook. In the years that I've done this, both in practice and as serving as probate judge, you get a lot of folks that don't have a clue what their responsibilities are. And some lawyers are really, really good at communicating that, and some are not. And some clients are really, really good at listening, and some are not. So I've had those occasions where I'd sit down and just feel like, okay, we've really had to come to Jesus on this. They understand, and then 5 days later I get a call and they have done something completely outside the scope of what they're supposed to do. So what we ask is that before I grant letters of administration in this case, you review the administrator's handbook, you sign it with your client on the back. Now look, I am very much a lawyer's judge, so I'm not trying to, nail some lawyer for something he did or didn't do. Really, in my mind, it's a protection to the lawyer, to where they sign up and say, look, we went over this thing. We sat down in my office and we talked about it. They should understand, what the responsibilities are. Okay? So in going back to in 43-222, it talks about the disqualifications of who can serve and who can serve and who can't serve. So the importance of having the name of the petitioner, the majority status, are they over 19? Because that's a specific disqualification under 22. And that they're an Alabama resident, which is specifically a disqualification under 22. That's probably the biggest conflict I have over this, because everybody will come bringing a petitioner. I won't say everybody. Many people will come bringing a petitioner, and they live in Donaldsonville. I was appointed as an administrator over an estate several years ago before I was on the bench, and the father, 45-year-old guy, died intestate, no children, no family except a father and mother who lived in Mariana. Well, I think Arnie False was the attorney in that case, and the court asked me to serve as the administrator, and Daddy was bent out of shape that he couldn't serve. He was as close to him as I was. He lived in the south part of the county. But it took a while for him to understand it's just an issue of law. You can't serve as an administrator if you're not an Alabama resident. So in your petition, we're looking for those things to determine the appropriateness of this appointment. The petitioner's relationship to the deceased. Well, that matters because 43-242 tells us who has priority. Judge Holloway and I were just talking about a case that he's got, and that comes to my mind right off the top, who has priority. And 42 says the husband or the widow, or the next of kin entitled to share in the distribution, or the largest creditor, and this is an interesting, and I have this one come up from time to time, the largest creditor, and it goes on to say, of the estate residing in the state. So a lot of times, or on several occasions, I've had creditors come forward and want to serve, but they don't meet priority because they're not in the state. And then fourth, in all of the counties except for Mobile and Jefferson, it's any other person that the probate judge appoints. Now, if you'll notice, if you're filing this in Jefferson or Mobile County, the progression is a little bit different. After the largest creditor, it's the county or general administrator, okay? As opposed to the fifth option, any person the probate judge might appoint. Now, I have a county administrator as well in Houston County, so that would probably be my next progression as well, is to appoint the county administrator. County administrator is bonded, and we'll talk about that on all cases, plus they're under an umbrella bond that covers any deficiencies. So that's why we're wanting to know that relationship, the name and residence of the deceased. Well, if you look under 40 sets forth the jurisdiction to determine which county has jurisdiction over this proceedings. The date and place of death, of course, that's partly to jurisdiction, but it's also partly to address the issue of who has priority. Now, I mentioned under 42 there's the progression of who has priority to serve, but also in 43 it says that any person can relinquish their right to serve, but in 43b says if in 40 days, if no one in categories 1, 2, or 3 have petitioned to serve, they have by default waived their priority. Okay? So I've been in those days where I represented administrations, and we're kind of waiting for our 40 days to run, and a lot of times I'll see folks now that aren't familiar with this particular statute, and they come to the court seeking an administration, seeking letters, and the time's not expired, and somebody of a higher priority has not yet relinquished or waived their authority to serve. Okay? Deceased died intestate. This is another allegation that we need to see in the petition, and that causes us to determine several things. One, are we heading down an administration or a testate probate process? It also starts to ring the bell about bond, causing the court to realize if they're intestate, they're going to have to be bonded. Okay? Also in that petition, we want to see that there's a distinction between the real and the personal property alleged within that petition so that we know which type of assets they are. Why does that matter, guys? Any idea? Too early to tell? Well, if you guys think about, and I have a lot of people that have a misconception about this or questions about the whole devolution of real property. Do you understand that concept that under law, and either under a will or administration, real property devolves to either under a will, those named in the will, or in the absence of a will, to the next of kin or to the heirs at law. Okay? Now, is there any restrictions on that? Well, sure there are. It's all subject to creditors' claims, spousal rights, elective share, all kind of, it's subject to pull back in, but it still, under law, devolves to, that's kind of why in the old days, now I always did administrator deeds, but that's, and some of you guys may do that, you may not, but it was kind of common practice in the old days that lawyers just wouldn't even do a deed because they said, well, it devolved to the heirs. Well, it did. I think from a title standpoint, this is a whole other issue, but from a title standpoint, I think it's helpful to have that administrator's deed to shore up the chain of title, but that's a whole other animal. The estimated value is required under 43-2-851, and the reason we want to know the value is because you got to be bonded. And you may ask, well, why are, in days gone by, probate judges maybe, and some may still not understand the urgency of bond, but there are many, many reasons to ensure that bond is provided for the assets of the estate. But for my wife and my 3 kids, you know what the most important one is? The probate judge is personally liable if I have an insufficient, if I don't set appropriate bond. Now, I sure hope that gets changed in legislation in coming days. The Probate Judges Association has really tried to push for that, but that'd be rough if that was on the circuit court, wouldn't it, Judge Holloway? So, yeah, probate judge has personal liability if there's an insufficient bond. So, I'm going to really be looking close, guys, to make sure I've got sufficient bond. So, we need to know what the estimated value of the assets of the estate are. You need to name the heirs at law and the next of kin in that petition, and then you can kind of proceed on with your petition. Now, one thing that's unique about the petition for administration as opposed to the petition for letters testamentary is you don't have to give notice to the heirs and next of kin when you file that petition. Okay? The only time you're going to have to do that is if you're seeking to get immediate letters and you're seeking to circumvent the 43-243 where it says this is the priority. Okay? So I'm going to have to set that for a hearing. If you're saying that, then we're going to have to give notice to, if we know that Mama's not going to serve and somebody else down the line wants to serve and you're the next one in line, then we need to serve her so that we can go ahead and move on with that. Under the code, this is kind of interesting. The petition does not have to be a sworn petition. However, it does require that I take testimony of witnesses if it's not sworn. So from a practical matter, it's a whole lot easier if your petition is a sworn petition, because otherwise I'm going to have to set it for a hearing. We're going to have to take testimony from witnesses to be able to admit that will to probate. Okay? Listen, guys, if y'all have any questions, I know this is kind of boring, but you guys ask me anything you might have. When you start talking about who gets to serve and why they get to serve. The underlying public policy idea is that they want the ones having the greatest interest in the estate to be able to administer the estate. And that's that basis behind 43.242 when it talks about a non-resident can't serve. But the other limitations to that are if they've been convicted of an infamous crime, intemperance, want of understanding, or improvidence. And I thought, well, I'm not sure what improvidence is. It's not a term that I was familiar with, but I looked it up and it says it's a lack of care and foresight, thrift, or business capacity as would endanger the estate. Now there's a fine balance here because when you guys are looking for, who can serve, who's in priority, you've got to go in the progression, who has the right to serve and in what progression that is, starting with, the husband, the widow, the next of kin, the largest creditor. And it's mandatory. I don't have any discretion to not choose the person in priority over the person in lower priority unless they specifically meet that standard of not being qualified because of one of those things. Okay? Now, from a practical standpoint, one of the things that we have recently found that is almost a litmus test in your ability to serve is your ability to be bonded. I don't know if y'all's experience has been this way, but in the last several years, the bonding companies have really tightened their belts on who they'll bond and who they won't bond. So, that's one litmus test right there. If you come to the court and your client can't be bonded, then that's going to be a problem. And I know for you guys that do personal injury and wrongful death cases, that's a big deal because y'all are looking around to try to find somebody that you can bring forth as a plaintiff in a lawsuit once the administration's opened. And I understand that y'all are trying to find somebody, and sometimes that's difficult. But my concern is there's still a duty, a fiduciary duty to the underlying estate that requires that somebody that serves in that capacity has got to at least be financially stable enough to be bonded. So, the obligation that they're bonded in the court kind of rolls downhill that if they can't be bonded, they're not capable of serving. We talked about the 40 days. After 40 days, all preference is lost and anybody can apply. But in no case can letters be issued before 5 days after death. Okay? Now, that's the petition. All those things I just talked about are really things that we're looking for in the petition. Okay? Now let's go to additional documents that you would have when you come to the court and you petition for letters of administration. We need an original death certificate. Usually that's not a problem. It usually takes 3 weeks to get a death certificate. Sometimes that's a problem for any number of reasons. One, we won't deal with the whole issue of presumption of death, but that's one issue. The biggest issue is that we need an administration open sooner than we can get the death certificate. Or for whatever reason we don't have a death certificate. If you file a motion, guys, saying, look, giving credible evidence that this person is in fact dead and present witnesses to cause me to believe that he's in fact dead, we'll proceed without an original death certificate. But that's, the death certificate is just the presumption that, a legal presumption that he is dead. The next thing is this administrator's handbook. Before we'll grant letters of administration, you've got to have gone over this with your client and signed off with them, okay? If you'll notice on the very last page is a certificate or certification where you guys both sign, okay? Then the other issue is bond. Some bonding companies have been kind of quirky. I never had this problem in years gone by, but recently some agencies will, it's kind of which comes first, the chicken or the egg. They won't give bond until you have orders or a letter, but I won't give letters until you have bond. So we got into a little bit of a standoff on this, and what I've come to is just the the agreement that most all of them will accept the order appointing. Okay? So if you have to have it, I'll give you the order appointing and hold the letters until you get your bond, and then when you turn in your bond, we'll give you your letters. Okay? The bond's got to be equal to the aggregate value of all the fair market value of the assets held by the personal representative, plus 1 year's estimated income, and that can be reduced by any securities that are held in some kind of fashion that would require a court order to release them. Okay? And we do that on occasion. I'll issue an order to some fiduciary agency and prohibit them from distributing those securities without a specific court order. So that's one way to reduce the bond. And then also I exempt real property. I think most people will do that. And the reason I exempt the real property is because an administrator doesn't have the right to sell real property without a specific order of the court anyway. Okay? So now we'll occasionally see it. We'll occasionally see where an administrator has sold real property. Most of the time it's they just did a deed, sold it to somebody, and went on their way. That's another reason why this certificate protects you guys. Like, look, I told them. They signed off. We both signed off. They knew they couldn't do this. But in other occasions, we've had on rare occasions that a lawyer will close it. Close a real estate transaction with letters of administration. Never close a real estate transaction with letters of administration without a specific order of the court authorizing that transfer. Okay? And the reason is, guys, let's go back to the devolution of real property. Theoretically, that property devolves to the heirs at death. And the only way that that can be pulled back into the estate is two ways. One is at least one of the heirs files a motion in the court and says, this can't be divided any other way. And then with one heir doing that, it can be sold. Or the personal representative has to file a motion in the court that says there are insufficient other personal property assets to satisfy the debts of the estate. Okay? When that's done, that triggers the pullback into the estate of that real property. So, understanding that theory of law, without that happening, the administrator's got no authority to transfer it. Okay? All right. Right now where we are, the county, I've been very fortunate in this. County Commission approved a deputy chief clerk position for me this year, and I'm in the process of interviewing, so if you know of anybody that's open the 16th, if you know anybody, it doesn't pay enough for a lawyer, although I would love to have a lawyer, paralegal, somebody that really has a good grip on what the understanding of the law. And what that deputy chief clerk is going to do is they're going to be responsible for all judicial functions in the office. If you know, at least in my county, the chief clerk has 40 people to manage, $40 million budget, a lot more than she can say grace over to be in court with me every day. So she's really disconnected from the court, okay? So the deputy chief clerk will serve as the judicial, what you might recognize as the chief clerk in most other smaller counties, okay? So what that person will do is be in court. Hopefully it will give much more continuity from the bench to the lawyers, because now I don't have anybody in court. So when you guys call up Joanne, my legal supervisor, and you say, well, the judge said in court, and she doesn't, I'm terrible at making good notes, so she doesn't, there's a kind of a gap there. This deputy chief clerk will be in court, and one of the things we want her to do is to prepare all of our orders. So once we get her up and running, hopefully by the spring of the year, she'll be preparing all of our orders. Okay? So you guys won't have to do draft orders anymore. But right now, these are all the things that you have to provide, as well as the order granting letters of administration, your letters of administration. Now, it's not uncommon that I will put some restrictions on your letters of administration. Some of those restrictions might be, and we'll talk about probably some of this in a minute. Y'all better keep me up on my time, okay? Some of those restrictions might be, You can't sell real property, which shouldn't have to be on there, but it sometimes does. Here's another one, guys, that probably may affect y'all, and it's kind of out of my order that I want to talk here. A lawyer may not hold more than $10,000 in the trust account of client money. Okay? And I don't know that y'all know that that's a prohibition in my court. It may not be in other counties, but it is in mine. And I know I did it. I did it myself. Never liked to, but I did it on occasion. Here's my limitation. No more than $10,000 in a lawyer trust account for more than 60 days. Okay? And I understand there are times, I get it, sometimes I didn't trust my client so much. You know, y'all I'm sure never had that problem, but I did. I just wasn't so sure about my client. And then two, it's just easier. I felt more comfortable about it. But the problems is you're not bonded under this estate. The personal representative's bond does not cover you. You may not have professional liability insurance, malpractice insurance. On the rare occasions that I have approved this, I have asked for the lawyer to submit a copy of his declaration statement from his malpractice insurance to show me that he's got professional liability insurance to cover the amount he's got in his trust account. And then lastly, guys, if a lawyer absconds with the money, you got no good recourse really. I think what is our client security fund, is that $10,000 limit? Isn't that what it is? I think that's what, if you go to the state bar and appeal to the client security fund, I think that's a $10,000 limit for you there anyway. So that's kind of my confines there. So that's kind of some of the restrictions you might see on there. Here's another one that would be important to you guys. I may put a restriction on there that you're not authorized, the administrator's not authorized to settle a personal injury case without prior court approval. Okay? So if you've got that kind of restriction on your letters, just be aware of it. It's no big deal. If you can come into court, show that it's reasonable to all the beneficiaries of the estate, we move through that. It's usually not a problem. But that's one of the things. Here's one of the pitfalls. And guys, I know, I'm presuming by why you're here today, you're really looking at the administration as the vehicle to get to where you're going, the plaintiff's case. But me, just a poor little old probate lawyer, I'm a stickler about how we do this side, okay? So the creditors, man, that is a trap that we see people fall into all the time. The administrator has an obligation to serve notice on the creditors, and that's got to be done in two ways, and it's got to be done very specifically. You've got to state the name of the deceased, the date letters were issued, by what court, stating in which county, and informing them that they have a right to file their claim or be barred by law. Now that's 43-260, and that's further articulated in 61, in which 61 breaks down the two types of notice. One is the actual notice, and this is where people mess up. There's actual notice and there's general publication notice for unknown creditors, right? Actual notice is the obligation to give actual notice to any known or reasonably ascertainable creditor within 30 days of the grant of letters. We will get folks all the time, we'll get the final settlement, and it appears from testimony to me that maybe wasn't known, but that should have been known. That was reasonably ascertainable. Did you get the mail? Well, yeah, we got the mail. Well, yeah, that bill came every month, but I didn't, they didn't ever call. You've got a duty if they're reasonably ascertainable, and that's a fairly easy one. Some of them are a little more, you knew he had power. You knew there was a gas bill. You know what I'm saying? Even if you didn't get the bill, you knew or you should have known. So creditors are a big deal. And actual notice under 60, subpart 1, says must be given as soon as practicable by first-class mail addressed to the last known address or by other methods reasonably calculated to serve actual notice. And guys, it can get a little tricky. If the dad-burn credit card companies, if y'all's clients that way, over time you've got 5 or 6 statements that you've got over time, and they every one have 8 different addresses. I mean, where do you send it to? I'm of opinion in my court, if you show me, you allege in your petition, and it's supported by evidence of the invoice, the bill, that you sent it to the last known address that's at least on that bill that says this is where you send payment, then that's good enough for me. Okay? Now, I don't know what they'll do to me on appeal, but I think it's a reasonable approach. But I don't know if that's been y'all's experience, but they will send, every bill's got a different address on it. And it's impossible to get anybody to talk to. Okay, I'm doing okay, aren't I? So that's that. And the publication, it's supposed to be 30 days from the grant of letters. Okay? And it's got to be published for 1 week, once a week for 3 weeks. And that's for all unknown creditors. What I see a lot of folks do, and this is a little quirky thing because 43.262, I think, says it's the probate judge's duty to ensure that publication is made. Then it goes on to say the administrator can't receive, the penalty if the administrator fails to do it is the administrator can't get compensation. So that's going to, if you don't walk your clients through this, they're going to be really upset when you get to the end and they don't get any compensation because they didn't file the publication of notice to unknown creditors within 30 days of the grant of the letters, okay? Now, I've not been on motion of the court, held anybody's feet to the fire on that. But just understand, if heirs lawyers come in and object to that, that's going to be a problem, okay? All right. Inventory. Here's another big deal. And guys, I'm going through all this in such minutia because if you're like a lot of my kind of plaintiff lawyers friends, this is all a frustration to them. They really just want to go through the administration to get to what they really do, which is plaintiff's work, you know. But this is important stuff. So the inventory, and 43.2.835 says it's got to be listed with reasonable detail, listing the fair market value as of the date of the death, and list any encumbrances thereto. Now, here's another twist that I require. The code says it's got to be submitted within 60 days. In my court, I require a preliminary inventory within 20 days. And the reason I do that is because we run into problems over and over and over again about a lack of bond. Between bond and your clients kind of doing crazy things, we'll get to final settlement and they will have, or we'll get to the first hearing and they'll give everything in the house away. Now, personal property does devolve to the heirs, but it's still subject to the claims of the state. So, doing that in inventory, and look, we're not hard on that, but we do it says in there, you know, in 20 days you've got to submit a preliminary inventory. Now, you're supposed to allege in that petition what you think the value is and whether it's real and or personal property. 20 days later, I want to know what's in there. What are these assets? Is it correct? Is it not correct? Here's a story. Probate judge in North Alabama goes to a hearing. This actually is a conservatorship hearing. The requirement of dates are a little bit different, but the same concept. Go to a conservatorship hearing. Granddaughter seeks letters for grandmama, and son doesn't show up for the hearing, so granddaughter receives letters of conservatorship. They contend that there's probably not more than $50,000 in the conservatorship. So the judge says, okay, bond $50,000, and if you find out that there's more, we need to increase the bond. Here's a reason that I want my court to do our own orders. You know how it goes. 10 days later, that file is on the judge's desk. He goes through it with the 50 other files that's on his desk, and there's orders granting, and in it says bond of $50,000. So he signs off and rocks on along. Well, lo and behold, over time, granddaughter finds that there's $800,000 in grandmama's name. Well, she takes her letters of conservatorship and she goes to the investment company and she makes a POD designation naming brother in Texas who is otherwise incapacitated in Texas on government assistance as the pay-on-death beneficiary. Within some time, grandmama dies. Investment company pays all the money to brother in Texas, whose astute lawyer says, oh, he can't have this, who promptly disclaims all of it back to granddaughter, who sells her house in North Alabama, buys a condo at the beach, and moves. Well, lo and behold, comes rocking along son, who now has a great interest in mama that he didn't seem to have before, and he finds out that grandmama, or to him, mama, had $800,000. Then comes the lawsuit, and the judge gets caught in the middle of it because what was his bond? $50,000. Should have been $800,000. So it ended up costing between the county and the investment company $800,000, and I'm sure they had a collateral suit to recover against the granddaughter. But that's kind of how this thing works. Inventory is very important. 20 days for the preliminary, 60 days for the final inventory, and then supplemental inventory. Everybody seems to forget about the supplemental inventory. That's required at any time in the future when you determine there are additional assets, there's destruction of assets, or the value of those assets has changed. If you realize grandmama's picture on the wall is really a Picasso and you thought it was a Sadie's, well, now you need to amend your inventory, okay? All right, and I'm going to try to move on. I got so much I want to talk about and no time to do it. We set, as a default, a hearing on delinquent inventories. So as soon as you file it and letters are granted, we're going to set a hearing for 60 days. And it's just a mechanism to try to change the culture. In days gone by, and maybe many other counties they do this, you might not ever be called or questioned on not submitting your inventory in 60 days. And it might be 6 months, it might be 2 years, and they might finally decide, oh, you never did your inventory. In Houston County, you're going to have a hearing date set on the 63rd, 4th, 5th day for a delinquency of your inventory. Now, if you file it, we just dismiss the hearing. The reason we do that is because we don't want to have to wait until it's delinquent to then start setting a hearing. So we go ahead and set a delinquency inventory by default. That inventory's got to be signed and it's got to be verified by your client. All right, let's see. All right, now the next thing is an annual settlement. Every year, once a year, you've got to do a settlement on an administration. A lot of folks don't realize that, but we set that for hearing, and you've got to do your annual settlement. Now, you can, the personal representative, depending on if you've exceeded the claims period, which you should have, what would hold you up from exceeding the claims period in a year? Well, if you hadn't published, you know, it's got to be 5 months from the last publication. So sometimes if somebody's messed around and forgot to publish, or you didn't get proof of publishing, or the newspaper that makes a mistake and didn't publish it, then that could exceed your year. But otherwise, if you've exceeded your claims period, then the personal representative can get a partial settlement on their administrator's fee at that point. Okay, that also is, we talked about the sales of land. Let's go back to estate claims. 43.2.350 talks about claims generally. 43.260 and 61 talk about the notice of claims. We talked about the 6 months from letters as being the limitation and 5 months from publication. And then in 371 talks about the priority. The priority of claims, let's see. Lays that out to who has the preference. And this is important because if you end up, you know, who's got some money here and who doesn't, who's going to be paid and who's not, it all is all based on the preference that's set forth in the code section. And that code section tells us that first it's going to be funeral expenses, And then after funeral expenses are going to be the cost of the estate and administration of the estate. And then usually the third big one is the, and that's 371, is the cost of last illness. So that usually eats up most everything for the claims. Now, as to the claimants, they've got to file a verified claim specifying the specific debt, and they've got to do it within the 6 months. Here's part of the problem I see with administrators. They want to protect mama's good name, and so they want to pay these claims. You're not authorized to pay claims unless they file a claim. And if they don't properly file a claim, you are prohibited from paying that claim. So most of the time we work that out. Most of the kids want to pay mama's debts and outstanding bills. They want to keep mama's good name. And I don't have a problem with that as long as everybody's on the same page. The administrator needs to know, though, if they're paying them and they're not properly presented, they're outside their scope of authority. Okay, estate litigation. All right, the 65410 says the administrator of the estate is the proper party to bring any estate litigation on behalf of the estate. 432833C talks about that administrator being the proper party and having standing to sue on behalf of the estate. Okay? Now there's a distinction you guys probably are aware of between a personal injury case and a wrongful death case. In a personal injury case, those assets pass through the estate and are subject to creditor claims. Wrongful death cases and wrongful death recoveries are not assets of the estate, and they do not pass under the estate. They're not subject to creditor's claim. They're not subject to funeral bills, not subject to any expenses. And here's one that came up for clarification last summer in Ex parte Rogers, summer of 2013. Supreme Court handed down that that includes an administrator's fee. So an administrator does not have a right to an administrator's fee off of wrongful death proceeds. It all passes to the heirs at law. Now, the reason that's so important is if you guys have looked around for a party plaintiff and you've kind of walked down this path with them to help them get the letters of administration filed, and they're not put on notice that they won't get their 2.5 in, 2.5 out ballpark as an administrator fee on the wrongful death, you might have a very upset client. So I would just say make sure that that's a discussion that you have with your clients in any wrongful death case to understand that they won't. Now, the way you deal with that is you guys just have they have a contract with the other heirs that provides for some compensation for them. Okay? That's the alternative way around it. All right, now in annual accounting, and we talked about, and then the final settlement at the end, you've had to have your annual accountings every year, but ultimately at the end, when you want to close this, and we're going to hound you till you do, you're going to have to file your approval of that final settlement, and then your petition for personal representative's fees, if it's appropriate, your petition, your bond waiver, your orders, your consents. Now, you didn't have to have consents up front, but you do on the back side, okay, from the heirs at law, or you got to have a hearing, okay? And you just file a motion to set a hearing if you can't get everybody on the same page. Now, when we talk about the bond, this is one thing that I didn't talk about. When we're looking at the value of the estate, that's what we're going to use to calculate what bond's going to be required. But in all cases, plaintiff actions as well, in Houston County, there is a minimum bond requirement of $10,000. Okay? I want to know that there's some leverage over that administrator to do what the administrator is supposed to do. I want to know that they've got some skin in the game. As when I used to do business work and we'd negotiate businesses, we would Everybody that came to the table, you wanted them to have some skin in the game. That bond is some leverage over the top. In days gone by, I know none of you guys would ever do this, but in days gone by, we had cases where there was an administrator appointed, lawyer filed, they did their investigation and determined there wasn't really a viable action. And then the lawyer filed a motion to withdraw, and then I've got, an administration with an administrator that doesn't know what they're doing, what the responsibilities are, and they're unrepresented. Now, from the probate court, not all probate courts take this approach, but in deference to you guys and in deference to my staff, we don't let anybody do any pro se representation in the probate court. Everybody's got to have a lawyer. So then that puts it kind of in a burden of people coming to my staff now for the next year, 2 years, going, well, every time we send them a notice, I don't know what to do. How do I close this estate? Well, if we've got a bond and I won't let a lawyer out until we close that administration, that kind of helps seal it up, okay? Now, lastly, okay, I got to quit on it. Lastly, let me just go over what we see as maybe some issues in the probate court in Houston County. Addressing missing names or missing parties, missing heirs at law, missing information off the petition is important. Please put the attorney's name on all the pleadings. I get a lot of petitions that don't have any lawyer's name, and then here I am. I don't want pro se litigants, but it's kind of hard for me to determine who's representing this person, particularly if they're out of county. A lot of times we're scrutinizing notaries, and we can say, oh yeah, that's so-and-so's, that's their secretary, I know who that is. But a lot of times if you're out of county, I don't know, so I need to know your name on your pleadings. The pleadings fail to describe the real and the personal property that's there. Bond, you'll submit the bond, but the administrator doesn't ever sign the bond. Make sure that gets signed. Original death certificate, the handbook signed. The non-Alabama residents get offered up a number of times as administrator. And then lastly, the proof of publication. If you're not careful, that'll just be off your radar because that's outside your office. The newspaper's doing it. You just kind of, 9 times out of 10, they just send that affidavit back to you and you submit it to the court. But that one time, they didn't ever send it and you didn't catch it, and you get to the final hearing and you realize, oh, I got to get that affidavit. And we can't proceed with the final hearing. Or in a worst case scenario, they didn't publish. You sent it, they didn't publish, you missed that somehow. So that's kind of what I want to talk to you about. I hope that wasn't too boring. I hope it was helpful to give you some kind of guidance of what we are doing in Houston County. And in any way we can help, please don't hesitate to call us. I gave you my judicial supervisor, Joanne Cherry. She's been there 25 years. She does a great job, and she knows the kind of ins and outs of this. She made the mistake of giving me her little cheat sheet a couple of days ago, and she was on vacation yesterday. So I just made a copy of her cheat sheet, and I copied her business card and put it on the bottom. Now, it doesn't look, she'll be ashamed if she saw, that didn't look good, Judge. I think, well, they don't care. Because a lot of people call, what do I got to file, how I got to file that, what's that going to cost me? That's a little bit of a cheat sheet that she uses, as well as her name and number and her email address. Guys, we are here to serve you any way we can. You don't hesitate to call us, and we'll be glad to meet your needs any way we can do that, okay?